Danny Sosa.
Mr. Sosa, I accepted your plea of no contest to the charge of unauthorized use of a motor vehicle.
Thank you, ma'am.
That was on December 10th, 2021. What I'm going to do is I'm going to show you the indictment on that back screen, and I'm going to read the habitual enhancement allegation. And I'm going to ask that you plead true or not true. So are you the same Danny Sosa that in cause number 2000 CR 3220 in Bexar County, Texas, was convicted of the felony offense of aggravated assault with a deadly weapon? Is that true or not true?
Yes, ma'am.
Is it true or not true?
I say yes, ma'am. True.
No.
True?
You have to
Okay.
use that word true.
Okay, true.
And then are you the same Danny Sosa that in cause number 2011 CR 0418 in Bexar County, Texas, was found guilty of the felony offense of assault, family choking? Is that true or not true?
True, ma'am.
I will enter a plea of true for both enhancement counts, and I do find that they are true. So now what you're looking at is a second-degree felony. This is a cap of 10. It's silent on your application for probation. I have reviewed the TAP evaluation and the PSI. Is there anything that you want to add on behalf of your client, Mr. Martinez?
Judge, I just want to ask Mr. Sosa a couple of questions.
Okay, go ahead.
Mr. Sosa,
Wait, hang on. Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this cause shall be the truth, the whole truth, and nothing but the truth, so help you God?
Okay.
Yes? You have to answer out loud.
Okay.
Yes?
Yeah, that's a yes.
Okay, thank you.
you can probably lower the mask just while you're talking because we
Okay.
can't hear you very well. Okay, so Mr. Sosa, why are you asking this court for probation?
Because so I could stay outside and do some help, and I know the classes, I know the class, yes, sir. Oh, sir, I know some class, oh, you me look at you, okay, okay. Oh, yeah, I was asking for probation, sir. Maybe a small power class that wouldn't be. Stay out of trouble. Drugs are no problem, but if you need 1 to 7, that's fine.
Okay, and so you believe that you'll benefit by being supervised?
Yes, sir.
Okay, and that'll help you stay out of trouble.
Yes, sir.
You also believe that you need some help, especially with your alcohol issues.
Yes, sir. Yes, sir.
Okay, and there was alcohol involved in this incident, right?
Yes, sir. Yes, sir. Yes, sir.
You also understand that there's some restitution. There's some, it cost the gentleman money to get the car to pound, right?
Yes, sir.
And there may have been some repairs. Okay, and so if you work, you can pay back that restitution.
Yes, sir. Yes, sir. I can pay that back.
Right, and I mean, even though this was kind of a crime of opportunity, you feel bad about this, right?
Yes, sir.
Okay.
Most definitely.
And you're appreciative that the person this happened to, this person's okay with you getting probation. Do you understand that?
Okay, I appreciate it, sir. Very kind.
Okay, and even though it's not up to him, it's up to the judge.
Yes, sir.
You know, that is his opinion. Do you understand that?
Yes, sir.
Okay.
Thank you, sir.
No other questions?
State, this is a silent application. Is there any factual disputes that you need to speak to?
I don't believe so, Your Honor. I have no further questions for this witness. And that being said, the court does have the evidence before it by way of State's Exhibit 1 and attachments that are unobjected. As well, the court has the PSI before it. I think that all of the information the court needs to make the appropriate decision is before the court at this time.
And it's true, what your lawyer said about the victim actually speaking positively and saying that you should get a shot at probation, so.
Yes.
I'm going to grant deferred. I want to hold on to the deferred option for many reasons, obviously, for the high end of the punishment. So you know that there's 2 to 20 years that is still available to me if you don't go through with your probation obligations.
Understand?
So the fact that you're in front of me at this age, Mr. Sosa, really, aren't you tired? I think you're tired, right? You're tired of this life. You should be.
I understand.
You took this guy's car. I mean, that's not lawful behavior. That's
Yes, ma'am.
illegal.
I
You can't do
understand.
that. And then it was damaged significantly.
Yes, ma'am.
So that needs to stop. You need to find a different way. Committing crime is not the way you want to keep going. You need to hit the reset button and just get going with your life, because you're gonna, guess what? You're gonna have to pay that $2,000.
Yes, ma'am. Yes, ma'am.
I will make no other findings at this time. I will grant the application of deferred adjudication for 5 years. I'm not gonna issue a fine. There is restitution in the amount of $2,000.
Okay.
I actually just want you to focus on that. I'm not gonna order anything else, because I also don't need to supervise you for 5 years. If you pay those $2,000 off, you report. We're gonna do bi-weekly UAs to start. You need to stay clean. You need to pay this gentleman back. And I don't need to supervise you forever. You can get this done in sooner than 5 years, get it done and be off my docket forever. You understand? This is a plea bargain case. I did follow the plea bargain agreement. You do not have a right to appeal. Clerks, he did a plea in person, so everything is paper and I have it here.
Okay, Judge.
Thank you. You're excused. Have a seat in the front row. Probation is going to talk to you.
Judge, I'd like to make the court aware that I'm not on the court appointed wheel anymore. So when the MTR comes off, I'm not it.
Okay, let's get ready to go on Ian Niebla. Who's going to handle this one for the state?
Your Honor, Travis Rodriguez for the state.
Okay, let me call it. This is cause number 2021 CR 1634, the state of Texas versus Ian Matthew Niebla. Attorneys, please make your announcements for the record.
Travis Rodriguez for the state of Texas.
Robert Fuller from Mr. Niebla, we're ready.
Mr. Niebla is appearing in person. Go ahead and tell me your full name.
Ian Matthew Niebla.
This is an opposed application. Did you file an application? I'm looking for the application. Let me just make sure you did file an application, right?
I did, Your Honor.
For purposes of the record, I did receive a sentencing memorandum with, I mean, I can't tell you how many letters I read, but there was a lot of letters. Yes, you do have an application on file. So I did read those. Do you have any witnesses? This is an opposed application.
Your Honor, I don't have any live testimony due to the sentencing memorandum, and I just have argument whenever the court is ready for that. And then we did review the PSI and the tax evaluation, and I'll address those issues at the proper time.
State, do you have any witnesses?
No, Your Honor. Only argument, and state reserves its right to close.
Okay, argument then.
Thank you, Your Honor.
And I'm sorry, Mr. Porter, just for the record, that sentencing memorandum that was forwarded to the court, the state did receive a copy of that as well. I did have a chance to review it.
Okay, thank you.
That was going to be my first statement to the court. I did do that. And also just a little while ago, Your Honor, I forwarded it to Gretchen at the time, and maybe she's forwarded it to Travis at this time, an email that was sent to me after the memorandum had been tendered to the court.
I am in receipt of that email as well, Mr. Porter. Yes.
Thank you. And I'll address that email in a minute. I do not want to take up the court's time because I know that memorandum took the court's time. But that it was extremely important, Judge, because it wasn't just the letters, but the court would look in the gallery right now. This is his support system, an incredible support system. It paints a picture of Mr. Niebla messed up, and he took responsibility for his actions, Judge. But from that time on, he's taken responsibility for his actions. As those letters are saying, he started his own landscape company. He now has 5 employees that depend on him. If he is to go to prison, I'm kind of be scattered here, Judge, but it's not about just Ian. What I'm saying, Judge, I don't want to get up there and say, if you send Ian away, this is him. It's about the other people in the community and about his support system too. Those 5 employees rely on him. His company will go to farm. Again, that was his choices, and I understand that. Family, friends, they're all here to support him. They paint the picture of what he is, what kind of guy he's doing, what kind of job his business is doing, helping out the community. It's not just for him, giving a lot of free labor away to veterans. The TAP evaluation kind of bothers me, Judge, because it sat there and said he was not motivated at all. And if I may approach on it.
Yeah, I saw that. No, I saw the PSI.
Sure. Yellow goes to Lifetime Recovery, Judge. And that is an email from Lifetime Recovery. He attends 3 sessions a week. And just so the court knows, each session is a 3-hour session. So that's 12 hours. Plus he does individual counseling through that session for another hour a week. So he's spending 14 hours a week at Lifetime Recovery. That's not a person that's not motivated. That's a person that's very motivated. So I wanted that court to see that.